Good afternoon, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to talk to everybody today about some contracts. Everything we do today is based on contracting. You hear a lot of people tell you need to study contract law or you need to study trust law, and they're right. But first, before we get started, I want to clarify that a trust is the same thing as a contract. It's just a different kind of contract. What do you mean a different kind of contract? Well, generally, you have places like, say, John Deere that will draw up a contract with another company to paint certain parts. And so when they produce these parts at John Deere, they'll ship them across town to this other company locally that will paint the parts, that will then turn around and ship them back to John Deere, that then can and then ship the tractors out. That's a contract. Two parties. A trust is merely a contract with at least three parties. Trust contracts can also have 4 parties, 5 parties, 6 parties, numerous numbers of parties, wherein the parties are named by the grantor of the trust. The grantor of a trust is the one that's offering their property up for use. And they're going to assign a trustee to manage the use so that it's done beneficially. Okay? That's what a trust is. So basically, just a different kind of contract. That's all. Pure and simple. Now, in contracts of such nature, we have 2 different types. We have those that are expressed, and we call those express trusts. And then, of course, we have others that have people all confounded in these courts. And so we're going to talk about quasi-contracts first. And before we get into that, we need to know what quasi is. So from Black's Law Dictionary, 4th edition, we have quasi, and it's Latin, and it means as if, almost as it were, analogous to. This term is used in legal phraseology to indicate that one subject resembles another with which it is compared in certain characteristics, but that are intrinsic and material differences between them. Okay, so let's read this one last time and I'll explain a couple things. This term means it's not a word, it's a term. Used in legal phraseology, legalese, with which it is compared, or phraseology, to indicate that one subject resembles another. So when we talk about subject matter in these courts, it is only a resemblance with which it is compared, with which it is compared. So it has a standard which it is compared with or to. It is not the subject, it is a subject that is compared with or to in certain characteristics. Age, weight, eye color, hair color, sex, or gender, things like that. Calling compared to a name. But that are intrinsic differences, not intangible thought differences, but material, substantive material differences of intrinsic substance, valuable substance, internal substance, internal value, indication of value from an external source. Material differences between them, showing there's a separation already existing. Okay? And that is in Bicknell versus Garrett. Bicknell, Bicknell versus Garrett, Garrett. It says, it is often prefixed to English words. Notice, Latin. It's legal phraseology because it's a prefix to English, implying mere appearance or want of reality. Mere appearance or want of reality. What does that sound like? That sounds like color of law. And that's exactly what it is. It's just a coloring of law. So, we have quasi is a coloring of law. It is exclusively a term of classification. What did I just say earlier? It's a classification. Prefixed to a term of Roman law. So it's exclusively a prefix to a term of Roman law, which is often prefixed in English or to English words. It implies the conception, the idea, the intangible idea. Index is connected with the conception with which it is compared, is instituted by strong superficial analogy or resemblance. Age, weight, sex, eye color, hair color, superficial. Sufficiently, though, similar for one to be classed as the sequel to another. It is compared as a sequel to the original. Comprehend this, all this wording, people. It's very important. As it is written, so shall it be. Civilians use the expressions quasi contractus, quasi delectum, quasi possessio, and quasi traditio. Quasi contractus, that's the one we're looking at. Parts of a lawful contract. In regards to quasi contractus, again, it's Latin, of course. And here it shows, of course, it's a prefix to English. And so they institute English here and say quasi-contractus. In civil law, an obligation similar in character to that of a contract, which arises not from an agreement of parties, but from some relation between them. But that there are intrinsic material differences between them, which arises not from an agreement of parties, but from some relation between them. The relation between them is the information that was abstracted from the original genuine source and then documented as a sequel, sequentially, to the original issue. Sequential. An obligation springing from excuse me, an obligation similar in character to that of a contract, which arises not from an agreement of parties, but from some relation between them, voluntary act of one of them. Voluntary act of one of them. If or. An obligation springing from voluntary and lawful acts of parties in the absence of an agreement. In the absence of an agreement. So even if you put down, I do not agree, I do not consent, you're still volunteering to put that signature down. Remember, folks, I told you the story several times, and I'll tell it here. Out of jail, they wanted me to sign release papers. They wanted me to release my body and my services. Sorry, I'm done leasing myself. Period. I no longer sign. Well, you have to sign before we can release you. Well, that's just my point. Make me sign. They put down refused to sign. And yet I walked out. They can't make you sign. Quit volunteering. Quit it. Altogether. If you're going to sign anything, make it your document. You're the one granting it. Do it as a trust contract. Know who the parties are and assign them their duties. Period. Okay, so let's talk about the duties. The duties are the parts of a lawful contract. Parts of a lawful contract is that the parties must be competent. In order to be competent to contract, they first must know that we are entering into a contract. All parties must know that we're entering. Okay, this is not a mere agreement. This is going to be a series of agreements, meaning a contract. And since I'm going to assign you as trustee and you as beneficiary, it's a trust contract. Now the you is dependent upon who I assign. What persons do I assign? Well, in my case, I think I trust myself. I trust me, myself, and I. So I, as the grantor, am going to assign me, Keith Orland Little Estate Trust, as the trustee. And then I'm going to assign the all caps letter doing business as Keith Orland Little as the beneficiary. Now, I'm going to act as both because I'm the only man that can do such a thing. A trust, a private trust. Pure and simple. Contract. I assure you. All parties will agree on all parts of this contract. I assure you. All parties will give free and genuine consent in the agreement of this contract. So parties are competent to contract. They're going to give free and genuine consent. All details of the contract are going to be fully disclosed. I'm going to write them all down. There's going to be valuable consideration. I'm going to autograph and seal that sucker and $21 value to it. Guaranteed. There will be a certainty of terms, definitions included. There will be a meeting of the minds of me, myself, and I in the best interest of we, us, and our. Autographs or signatures. And of course, privity of contracts. So, what parts of a lawful contract are there? There are 8 enumerated. 1. Parties competent to contract. The parties to a being of the age of consent, of sound mind, not disqualified from contracting by any law to which she or he is subject. I'm only subject to the laws that I subject myself to, that are already written, that I already abide by, and any laws that I might write myself. A flaw in capacity may be due to minority, lunacy. I have been called a lunatic. Idiocy. I am an idiot, but I am far from stupid. Drunkenness. Not at this time. Or dissimilarity of kind. They're nobody else's persons. They're my kind of persons. The parties should be of the same kind, being either legal fiction, actors, or living men, women, allowing more than 2 parties, but never a mixture of these kinds and their respective jurisdictions. Free and genuine consent, the second part of a lawful contract. The consent of the parties to the agreement must be free and genuine. The consent of the parties should not be obtained by misrepresentation. Therefore, I seek the truth. I research it. I research it again. Sometimes I even research it again and again and again and again just to make sure. But most often I am assured of my own truthfulness, so that I'm not misrepresenting any information. The consent of the parties should not be obtained by fraud, undue influence, coercion, or mistake. If the consent is obtained by any of these means, then the contract is not valid or legally lawfully enforceable. I'm going to explain to you people that is, if you find an error in a contract, and this includes the name, any error in the name, then it is not valid, nor is it legally or lawfully enforceable. The record must be correct. If your name is Matthew, and it's spelled M-A-T-H-E-W, and they spell it M-A-T-T-H-E-W, it is not correct. It is not related to information between you. It is mistaken. It is misrepresented. Full disclosure, the third part of a lawful contract. When negotiating a contract, full disclosure is the step of providing all material information, intrinsic and material differences, material information, or telling the whole truth about any matter which may influence the decision making or the other party or parties before they decide to enter into a contract. If either party fails to make full disclosure, the contract is null and void. If either party fails to make full disclosure, the contract is null and void. Valuable consideration. The consideration is something of value, possessed by the parties, that is brought to the contract table. This is something of value that is bargained for and given in exchange for a promise, or a performance. The parties must each receive a benefit and each suffer a detriment. I want to explain here this use of the each receive a benefit and each suffer a detriment means that in order for me to give valuable consideration, I have to suffer a loss. I have to give something up. I have to allow myself to take from me or myself or I and give to someone else. It may even be a me, myself, or I party, but it may be a someone else party totally separate. And that means I have to give up a tangible good to another physical party and in equal other party. And this is where the contract is supposed to be of like kind, has to give me of something of substantive value. In other words, something of substance themselves or their own personal time and effort in labor, a service, in exchange for what I give. Even though I don't give my effort in labor and time by offering a service, it is still aligned in that exchange. The trust that we have going on here in the commercial system uses Federal Reserve notes as that substance and the only substance that they will allow you to exchange. No matter whether you have substantive property or time and service on the private side. When it comes to their commercial system, they demand the Federal Reserve notes. That's the fraud. Has no intrinsic value. It's the quasi-contract part. You agree to it by voluntarily using it. This something to be enforceable. A contract must have valuable consideration. So when the government says that you have to use these Federal Reserve notes for contracting with another man, even as a McDonald's corporation, saying that you have to provide Federal Reserve notes to the employee, they bypass that now by the electronics and the checking accounts and all that. And it's all fraud because it's still all the Federal Reserve notes that we use are extraordinary dividends of those financial instruments that they're using, unambiguous financial instruments that they're using as part of the entire fraud system. Quasi-contract. A contract is insufficient or unequal consideration without agreement. So, when they offer you this contract at McDonald's, it's unenforceable if they're not willing to pay you in lawful coin of gold and silver. And it is proven that that it's a quasi-contract because they won't offer you gold and silver coin as payment. They can't. The only instrument that they can use is an instrument provided by another private entity. And that's that third party. They have to create a contract trust. They have to create a contract as a trust in order to be able to use this commercial system. There has to be 3 parties to that contract, and that makes it a trust. That's the hidden trust. Pure and simple. Certainty of terms. The terms and conditions of the contract must be fully disclosed and agreed upon. They have to disclose that the similarity of their legal tender to the lawful coin system, they have to expose that and explain it. Certainty of terms. The certainty of terms. The terms and conditions of the contract must be fully disclosed and agreed upon. You have to agree to accept their legal tender as a form of payment. Payment, a very specific term for you. While on the other side, the public side, the one where they're using that all caps name, there's never a payment allowed because you cannot pay a debt with a debt. So we haven't offset the ledger. We haven't discharged the actual charge that's being charged to the person. Certainty of terms. The terms and conditions of a contract must be fully disclosed and agreed upon and must be certain and fixed. Any subsequent variation of terms must be agreed. So when these McDonald's corporations are hiring you, they're supposed to disclose that there's a quasi-contract here. And because we are as a corporate entity to use Federal Reserve notes in order to pay you, and we can't pay you in lawful coin of gold and silver, we have to disclose to you that the United States Corporation, which has taken away not only your ability to pay in lawful coin or be paid in lawful coin, but our ability as a corporation to do the same thing. They've taken away the corporation's ability to do that and instituted a legal tender, a fiat, in exchange for being able to compensate each other. But that still doesn't stop the ledgering going on behind the scenes. The Wizard of Oz that's sitting there pulling all the chain mechanisms, and he's standing behind the curtain and you don't see him. You're going along your jolly life thinking you're following the yellow brick road, yellow brick road. Gladly accepting payment instead of telling them no thanks, but I will accept that instrument and discharge what is being charged through lawful conversion under 12 of the United States Code, Section 411. Pure and simple. Certainty of terms. Any subsequent variation of terms must be agreed upon. Title 12 of the United States Code, Section 411, speaks of the lawful coin. And that right there is the variation. And it must be agreed upon. As it is written, so shall it be. I agree. You've taken away my ability to be paid in lawful coin. So through the paperwork and financial documents and instruments that you instrumentalize through the United States person, the 14th Amendment, under the employment, you'll see there's Social Security number, and I'm required to pay federal taxes. That proves it. And a state citizen holding dual citizenship under the 14th Amendment. And therefore, I am already and should be cognized as free of levy, not exempt from levy, but free of levy to begin with. Because that 14th Amendment person is sequential information from the original information derived from my being born live. Okay? So let's get this relation rectified and corrected on the record. I agree with 12 U.S.C. 411. Please make the conversion as you're instructed to. Public servant. Title or number 6, meeting of the minds. A meeting of the minds, consensus ad idem. Here I want to make it very clear. Again, referring to the 14th Amendment, people, consensus. When you're born, every 10 years they perform a census, and that is a gathering of the information that relates to you. And as you go about in life and you keep giving out this information that you really have no authority to do, you really have no authority to be giving this information out, and they tell you your security number, and that is the original instrument number that is operating all of these commercial events in your life. Quit giving it out. And when they force you to through some kind of medical need or something like that, you got to give your signature. Make sure you clarify that this is an agreement under 12 U.S.C. 411. Pure and simple. Quasi-contract, in agreement, 12 U.S.C. 411. Certainty of terms occurs between the parties when they recognize a meeting of the minds, consensus ad idem, occurs between the parties when they recognize each other. As it is written, so shall it be. I recognize the U.S. Code, as I recognize the United States Corporation, as I recognize 12 U.S.C. 411, that they have converted the entire commercial system. All crimes are commercial. Title 27 of the Code of Federal Regulations 7211, because they've converted everything to commerce and their commercial use, I have no way to pay. And neither does any corporation, including the United States Corporation, have a way to pay me. And this is proven by their insolvency and agreed upon under 12 U.S.C. 411. When they recognize each other, understand their mutual obligations. Okay. The mutual obligation is that I have to accept the benefit of the use of the Federal Reserve notes under a doctrine of necessity, because I recognize I have no way to exchange any gold and silver coin. The United States has already recognized this and put it on the record. I'm putting that out there and showing them that I am in agreement. I understand their mutual obligation under Title 18 of the United States Code, Section 8, clarifying obligations and other securities of the United States, which includes all bonds, bills, notes, certificates, coupons, checks, stamps, and canceled United States stamps and canceled United States. These are all debt instruments, financial instruments, instrumentalities of the United States that I am forced to use through the disqualification of gold and silver for a coinage. And therefore I agree through what it is written. I am allowed only the ability to discharge what has been charged. However, since they have no way to discharge what I'm charging them because they're already insolvent, they're already in debt, because like I said earlier, the information between us that is being misconstrued will prove that I am the creditor. I am the credit to which the creditor, the person that is used in this commercial system, was created by the debtor. A meeting of the minds occurs between living men, women in lawful matters, common law jurisdictions. A meeting of the minds cannot happen in the legal sector because it's all persons, and persons don't have minds. Persons don't have souls. They have imprints on papers called birth certificates, and those are footprints of little tiny babies, infants, minors, juveniles, delinquents. I'm an adult. You want to contract with me? I got to hear you. I got to see you. I got to speak directly to you. And I want your wet ink signature or autograph too. And between legal fiction actors in legal matters. In other words, in a legal matter, which is a legal contract, which isn't a contract, a meeting of the minds occurs between living men and women in lawful matters and between legal fiction actors. The persons can't be actors. Only I can perform like a person. And even that is still a third person abstract noun, total fiction. Because my time and services is still worthy of my hire. Plain and simple. I still deserve myself to be compensated. And between legal fiction actors in legal matters, Admiralty Maritime Jurisdiction, a contract must either be lawful or legal. Makes sense. If one party to a contract makes a signature as an accommodation party to a legal fiction person, while the other party makes an autograph for a living man or woman, the parties are of unequal kinds. And the contract is null and void. This is why they won't allow you to make those signatures on you, things like your driver's license, passports. You can't do that. It nullifies that contract. So why even bother signing? Don't reserve your rights. I'm going to talk about that when I'm done here. I'm going to talk about the trust of identification, at least my theory on it, in regards to contracts and quasi-contracts. 7, autographs or signatures. Lawful written contracts between living men and women must carry the wet ink autographs of the parties. Okay? Must carry the wet ink autographs of the parties. From now on, quit giving wet ink autographs. Quid pro quo. If they can stamp it, draw up your own stamp. Prince did this, or the artist formerly known as Prince did this, and he made a symbol and he started stamping that symbol. You think he sat there and drew out that symbol every day? No. He stamped that symbol. He branded his chattel, just like cowboy ranchers still do today. But instead of using an iron-hot poker, he used a pen or a stamp. All of them are similar devices. They are marking instruments. And all you're required to do is make your mark. It doesn't say that you have to literally put it in ink. Here, let me give you a little blood print. There's my mark, buddy. Symbolize that. So, the lawful written contract between living men and women must carry a wet ink autographs. And when I do an autograph, Keith in block letters and nothing more. If I'm going to put my signature, I'll do it in cursive with Keith Little. I don't include the middle name. That's how I've always been taught to sign. I was never taught to autograph. Imagine that. Yet all of these pro football players and pro sport players and pro entertainers, movie stars, singers, all these people, book writers, are doing these autograph sessions and they're giving signatures. Why do you suppose they're giving signatures? Because it's a commercial item. A commercial item doesn't necessarily have to be a contract item. Wet ink autographs of the party comprising living identifications such as a thumbprint, but more often living standing is recognized by an unambiguous declaration with a handwritten wet ink autograph, including the prefix I. Full colon, stop. And or the words, all rights reserved. Without prejudice, written below. Legal written contracts between legal fiction actors must carry the wet ink signature of the parties as an accommodation from a man or woman. Legal written contracts between legal fiction actors must carry the wet ink signatures of the parties. So when they require you to put a wet ink signature, they are proving that they are trying to get you to be the first one to give a wet ink signature on a presumed contract. Period. Plain and simple. Don't give it. Prove at all times that you have no willingness to voluntarily subject to something that you're not going to subject yourself to. However, if you're taking upon benefits and using that state or United States person, then you need to know how to give your signature. And that's just a plain signature. But in the background, know what's happening with those bonds. When you give that signature, provide the 1099 OID, 1099A, and the W-9 for the person that is the paramount or principal investor in signing that contract. Let them know you agree. I agree to this taxing event. I know how it works. I know why it works. And as the principal investor, let's get this party going. Because in 20 years, 30 years, when this bond matures, it's going to remain in my private estate trust and my heirs will be able to benefit from the income dividends provided on the return. They will take care of the taxes if I'm not still alive because I already have a successor trustee named. Imagine that. You got to think about this stuff, people. When you learn this stuff, learn how to put your private trust together, and this is what I'm talking about. When you establish your own private trust, you're creating your own private contract. A contract is between two parties. When you create your own private trust, you're creating your private trust between me, myself, and I. I am the grantor, person of the estate trust. Keith Orland Little Estate Trust. One person, and he is the trustee. Now, myself is another person. His name is all capital letters, Keith Orland Little. He is the beneficiary. He is the one that I will sign my name in at all times, Keith Little. By Keith Little. Doing business as Keith Orland Little, all caps, by Keith Little. Author? Autographed by Keith. Third person, Samuel Clemens, Mark Twain, wrote about Tom Sawyer and Huckleberry Finn. His persons, and he wrote about him through one of his other persons, Mark Twain. Mark Twain was the trustee. Tom Sawyer and Huckleberry Finn were the beneficiaries. Why? Because those are the ones we remember most often. Those are the names that are living in eternity. Privity of contract. Number 8, a contract exists only between the parties. When you establish your private estate trust, you establish your own private member association. Because they're all associated with each other and their information relates them all. Therefore, they can contract between each other because they're all competent to contract. They all give their free and genuine consent. They all have full disclosure. They've all given valuable consideration. They all come to a certainty of terms because they all have a meeting of the minds and all have given autographs or signatures because they're all privy to that contract. Now, anybody that wants to contract with you, they have to agree to your contract, which is your private member association. They have to agree to your rules and bylaws. Your rules and bylaws have to stand up to a higher standard than the. You have to be able to make them subject to your private member association. How do we do that? As it's written, so shall it be. They've already written everything you need. All you have to do is find it and agree to it. Agree to the separation. Make your statement of separation. Point it out to them. Show them it all. Okay, now I got some other things I'm going to read here, because this is all critical when it gets to going into these courts. These courts are private venues. They're performing contracts. Well, what kind of contracts? Well, you got a prosecutor, or a judge, or administrator, or clown, or magistrate, whatever you want to call them. But then you got yourself. They're creating a constructive trust off of a contract that is implied and presumed to already exist because it's written down, and they're trying to get you to agree. So stand up and agree. Go to your brother in agreement. Like I said, though, fill in those gaps. They're putting the prosecutor is giving certain information of the contract. The judge is agreeing, and all you got to do is fill it in. Fill in all the gaps and say, okay, I agree to this, I agree to this, I agree to this, I agree to this, I agree to this. They're giving you all kinds of information that you're not going to rebut, you're going to agree to it. You're going to find the loophole that says that, okay, well, this applies here, and you're going to say, well, it applies here, but in that instance, its application is subsequent or sequential to the standing that I have. And my standing is here, and its standing is here, so I override it. Therefore, I'm the moving party. But the only way you can do that is by filling in those gaps yourself. Otherwise, the prosecuting attorney or the plaintiff is the moving party. You're not filling in the gaps. That's all it is. Correcting the record. So when it comes to that, it's critical to remember that this is all paramount when it comes to these courts in regards to standing. And we're going to talk about that here in a minute. It says a promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. And this is back to quasi-contracts. A quasi-contract is an agreement upon sufficient consideration to do or not, this is contract. Contracts are a promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. A contract is a promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. An agreement upon sufficient consideration to do or not to do a particular thing. Okay, So when we think about these individual contracts where we're offering a service of our time and labor at a future time in exchange for compensation now, or in a future time to give our time of service and labor in return for compensation when we're done of substantive value, or in exchange for another service, then we have gotten rid of the legal comprehend that? An agreement upon sufficient consideration to do or to not do a particular thing, which is a promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. So when a contract is done right, it's made lawful and it destroys the legal relation. It destroys the legal tender part. Because anytime you're using the legal tender, it's a quasi-contract and it's voluntary agreement to use the commercial system. So therefore you always, in using Federal Reserve notes or financial instrumentalities of a foreign corporation, you always have to perform contracts as a trust. As a trust. Plain and simple. Everything in dealing with this commercial system. So when it says standing is the issue at hand in this particular action, December 26th of 1933, 49 statutes at large, 3097 Treaty Series 881, which is a Convention on Rights and Duties of States, stated Congress replaced statutes with international law, placing all states under international law. Now, December 9th, 1945, in conjunction with placing all states under international law, the International Organization Immunities Act relinquished every public office of the United States to United Nations. If in December 9th, 1945, the International Immunities Act relinquished every public office of the United States to the United Nations, those public offices are no longer in Washington, D.C., are they? Title 9 of the Uniform Commercial Code, Section 703, location of debtor, 307, location of debtor, clearly states as the United States is located in District of Columbia. Right there, comprehend this, people. When we talk about certainty in contracts, we have something here that says, under the International Organization and Immunities Act, relinquished every public office of the United States to the United Nations. But it says the debtor is located in District of Columbia, and the debtor is United States. If the United States is located in United Nations, isn't that United Nations is now the debtor? Remember, people, this is all part of the IMF, UN. It's all the same organization. Think about this stuff. 22 regulations 92.12 and 92.31, heading states that an oath is required to take office. Anybody taking an oath of the office of the United States is taking an oath to the United Nations. Title 8 of the United States Code, Section 1481, states once an oath of office is taken, citizenship is relinquished. Thus, one becomes a foreign entity, agency, or state. That means every public office is a foreign state. So even the public office of the United States, as we know it as people, is a foreign office, and now it's been removed to the UN, proving once again in a third tier that it's a foreign state, including all political subdivisions. Every public office is a foreign state. Every single court is considered a separate foreign entity. Title 22 of the United States Code, Foreign Relations and Intercourse, Chapter 11, identifies all public officials as foreign agents. Title 28 of the United States Code, Section 3002, subsection 15A, states United States is a federal corporation and not a government, including the judicial procedural section. Now, they changed the wording in that more recently here at the beginning of 2019. But it used to state, and though they've changed the wording, it is like wording, and so we can still refer to the old wording. It said, United States is a federal corporation and not a government. If the United States is a corporation, not a government, is it a public office? So where are public offices? Are they too in the UN? Shouldn't we have some people in that public office? Isn't that telling us that the people that are running the United States as a Congress of the United States is a corporation? Even Congress is a corporate. The executive branch is corporate. The legislative branch is corporate. It's all corporate. Period. Every last bit of it. Federal Rules of Civil Procedure 4J states that the court jurisdiction and immunity fall under a foreign state. Title 28 of the United States Code, Chapter 176, Federal Debt Collection Procedure. The Federal Debt Collection Procedure places all courts under equity and commerce and under the International Monetary Fund. In 1950, 81st Congress investigated the Lawyers Guild and determined that the Bar Association is founded and run by communists under definition. Thus, any elected official that is a member of the bar will only be loyal to the bar and not the people. Standing is critical to the proper functioning of the judicial system. And the only standing the United States has is in the commercial system, and therefore they have no standing when it comes to government. The United States is a federal corporation and not a government. They have no government, governmental, judicial standing. They only have corporate, commercial standing when it comes to judicial issues. They can only give opinions in a commercial style without any enforcement. And it's only by your voluntarily submitting yourself to their courts that you do this. Period. Now let's talk about the quasi-jurisdiction when it comes to the states, the United States, and the international forum. Because when it comes to these commercial instruments, like I said, the identification thing is a big issue. That 14th Amendment, oh my God. When it comes to the 14th Amendment, we have to remember there's a dual citizenship. And at the same time, we remember that dual citizenship. We got to remember we're all still crying and screaming that we're free. We're free men. We've got an international, unalienable inherent right to what's common amongst all of us, and that's international. Okay, so let's think about all these these different levels. When it comes to the identification, I think we need to do the same thing in a matter of a trust form and use the state identification, all caps name. That's the state ID, whether it be just a straight state ID or a state driver license. Now we've got to weigh a commercial instrument as card holder to perform commercially under our person in the state. We've got a United States passport, again, the all caps name, so that we are allowed to perform commercially on the federal level. And this allows us to operate the same way the federal government does in regards to the states, each of the states and every state, including your one state, in that Title 48 of the Code of Federal Regulations said that contract terms and conditions required to under or statutes or executive orders hyphen commercial item. And what that does is it tells you that you now have the ability to contract between both of your persons. You can contract between both of your persons with the state or the federal government or the international community to act as trustee and beneficiary in any further trusts. Comprehend that. Now, on the international level, the world passport. And it's not a commercial item, but a document detailing information between yourself and your two persons, of which you have card holders of both, to be able to perform commercially, internationally, as a state citizen with a United States passport, able to travel the world. So now you've got the world passport under the trustor name. You've got the United States passport as a trustee, and the state citizen as the beneficiary that's able to travel internationally and intranationally in and among the states, the 50 states of the Union, and all states internationally unionized. And that's how your quasi-contracting works. Show them you're the quasi. Show them the boss. So you have a higher jurisdiction than their mediocre U.S. codes and their mediocre state statutes, their insurance laws, their surety laws, their securities and exchange laws, their International Monetary Fund regulations, Federal Reserve regulations. Show them you know how to follow the supreme law. See, the whole world of commerce, Admiralty Maritime, tells you their jurisdiction is naval and belongs on the waters only. Of my land. You want to deal with me? You learn how to me privately. Because like I said, I want your wet ink signature. I want to talk to you face to face. I want to see you. I want to hear you. I want something tangible. Quit rubber stamping everything. Tired of that. So anyway, this is a little bit longer video than I expected, but always glad to spend some time with people and explain this stuff. Hopefully you guys are comprehending this, because I think it's important that you comprehend not just the lawful parts of a contract, but the different kinds of contracts and how they operate. So when we talk about a contract, it's not just simply a contract between myself and another man. It can't be a contract between myself and a person. I can only contract in a trust manner or a contract manner between my persons and other persons, or between myself and another man or woman. They have to be like kind. At the same time, we've got to get rid of any implications and presumptions and things that are not agreed upon that may reside there without being seen, because we automatically volunteer without knowing. And that's why I say it's important to learn your signature, your autograph, your mark, your brand, your trademark, your insignia, your logo, your symbol, a symbol, whatever you want to call it, your impression, your expression, your unalienable and unabridgable freedom of expression, freedom of the press, your freedom to press yourself upon the land, your freedom to press your pen in a scriptural manner or authoritative manner across a flat surface so symbols can be seen. Whatever you want to do. But remember, as it's written, so shall it be. So when you write something down or when you start believing something, you got to start acting like it too. You have to behave like it. And if you're going to act like you're performing commerce, then you have to pull your person out of your wallet. Pull that person out of your wallet. Let me do it this way so I can read it, because otherwise it's backwards. You pull that person out of your wallet and it's got all this information. Make sure it's not a misrepresentation. You know what I mean? Because when they want to pull me over for driving down the middle of the street on my bicycle, that's what they're going to get for their misrepresentation. See that? If I drop it, it doesn't land on any feet. If I stand it up, and try to let it stand on its own, it can't. It lies. It lies on its back or it lies on its face. Start looking for the lies on the face of the instruments. It's there. Correct it. Whether it be the state ID, U.S. passport, world passport, make sure they're correct by knowing what's correct about them and using them correctly. You can use them, but know how to. Create it in a trust form. Know who you trust. Do you trust me? Do you trust the person that you're contracting with? Do you know it's a contract? Or is it a quasi-contract that you're not aware of because you just volunteered and there's an implied agreement in there? Did you just sign that loan paper without reading it? Are there agreements in there that you didn't know were there and you just voluntarily signed without reading it? Did you let that banker shove you off that 75-page loan document and tell you, well, I'm in a hurry, I got other things I got to get done, I need you to sign this? Or did you take the time and due diligence to read it and learn the words that are being used in there and why they're being used in the manner they're being used, and realize they're using words you don't comprehend, and when you see that word that what? Well, no, it doesn't matter. There's something else more important here. More important to hurry up and get this read so I can sign it. No, it's more important to stop. Read it. See it for what it is. Realize The real lies with your real lies. See the lies on the face. See the lies on the back. Make them back down. Make them back down. Showing your jurisdiction up here. And you do that by correcting the record. So anyway, when I get done here, I'll go ahead and post pictures of what I just read, as well as a PayPal link. Anybody that wishes to help me out with gratuities, I always accept anything you can help with. Especially right now, I'm wanting to get back into that commercial society. So I need to go out and get a state ID. I need to get my world passport. I got to get some birth certificates, get them authenticated. Do all that stuff that I need to do so I can show people how to start operating professionally, proficiently, expertly in this commercial system. Because, and don't get me wrong, I'm not going to jump into it and you're going to see me doing all these magical wizardly things. I'm not going to do that. I'm going to go in step by step, timidly, but assertively, knowingly, with questions, still. That when I come up upon these events, I can say, okay, stop, take a minute, don't just volunteer, figure it out. Have patience, ask questions, observe, record, ask a question, resolve. Move forward to the next step. And in doing it that way, I hope, my greatest hopes is to show people how to do it the right way, no matter where you're at in life right now, that you can stop, figure out what your issue is, observe it, record it, find solutions, resolve it, and quit volunteering. Know what your signature means. Know what your autograph means. Know how to qualify it in various different ways. Why it needs to be qualified and when you shouldn't qualify it so that it can perform its purpose in that commercial system. If you're going to be using these instruments, the driver's license, you can't put UCC 1-308 and reserve the right, negating the contract. What you have to do, well, you can, I guess you could use that, but you have to be aware of the way it can be taken. And so when they try to refuse your signatures in these manners, you have to claim the agreement. You have to say, well, why? You have to ask them, well, why can't I? Well, they're going to say, well, you can't reserve your rights. Well, that sounds like you're saying I don't have any rights. So let's clarify what those rights are. Do I have a right to do this? Do I have a right when that policy officer pulls me over to say, well, to explain to him that I'm not performing commercially, I'm in my private capacity? When you're at the hospital and they want you to sign a document, and you say, well, I'm having a conflict with the certainty of terms here, you know. You're saying in this document here that I'm a United States citizen, when in fact I know I'm not, but I do own a United States citizen. I can't verily state that I am the United States citizen, but I am the card holder of a United States citizen. Would you like to see my passport? Let's correct that. Let's talk to your legal department. They're not going to want to talk to the legal department. They're going to find everything they can to try to get you to just sign that document. I can't voluntarily do that because I know the difference. I am not the United States citizen. I have clarified through a statement of separation. Would you like to see my statement of separation, verifying all the facts that prove that I am not the United States citizen, that this instrument is the United States citizen? Once spelled or written out my name in all capital letters. I was never taught to do that. I didn't learn the difference until I was an adult. Now that I know the difference, I can no longer go on that foundation of belief, because that would be a misrepresentation. Use the truth as your foundation of law and show them that their facts are incorrect, that what you've placed here is the truth, and they have to but then they can't just assert that you have to be a United States citizen. They gotta prove it. And when they've already proven on and for the record that you are not, that there is a clear separation by the information, then you can no longer abide by that. You have to admit to it. And when you admit to it and point it out clearly on the face of the record and shatter the lie, then they have to admit to it too. So now we come to an agreement. Now you've finalized that trust. And when you finalize that trust by clarifying the position that I'm the grantor, and the United States citizen is the trustee, and my state citizen is the beneficiary, of which I get to use international. Period. Plain and simple. That's how it all works. But again, I'll paste that. I'll post the pictures in the comments, and I'll edit the post text to include the PayPal link. And again, all this stuff is, like you guys know, it's not cheap. It's not cheap. Appreciate all gratuities, the 5s, 10s, 15s, 20s. Those of you that can help out with the bigger amounts, 50 and 100, I appreciate those. Anybody out there can help with 1,000. I need a new computer set up. I thought I had that resolved, and I guess not. But anyway, every bit counts. I'll paste the PayPal link, and I appreciate you guys watching. I appreciate you guys listening. I appreciate you guys taking notes. I appreciate you guys doing your own research. I appreciate you guys passing it on. I appreciate you if you do all of it, though. Every last bit. Partake in all of it. Don't just sit there and watch. Don't just sit there and listen. Don't just sit there and watch and listen. Don't just sit there and watch, listen, and hear me. Don't just sit there and watch, listen, hear me, and take notes. But take action. Be participants, please, in all of it. And remember, if it wasn't, God bless. Love you all. Have a great day.